Yes, we're now on time, 5:30. Hello, everyone. Thank you for joining us today. My name is Sammy Kim, Young ICCA Events Coordinator. I'm very pleased to welcome you today to our webinar jointly organized by Young ICCA and Thailand Arbitration Center, THAC. I'm joined by my colleagues at Young ICCA, Dominic Nottage, our Young ICCA co-chair, Raul Donde, the Global Events Director of Young ICCA. We would also like to thank THAC representatives who gave invaluable assistance to make this webinar happen today. Before we begin, just a few words about Young ICCA for those who don't know about us. Young ICCA operates under the auspices of ICCA, International Council for Commercial Arbitration, with the mission of opening the doors of international arbitration for young practitioners and students. Young ICCA is now over a decade old and includes close to 10,000 members from all around the world, to whom we provide access to free of charge resources and programs in 4 key areas. So first, we coordinate a mentorship program which connects small groups of Young ICCA members with leading practitioners for 2-year cycles. I was also part of the mentorship program as a mentee, and it was a great experience to connect and learn from senior practitioners. So I would definitely recommend that you take part of it. The applications for this mentorship program open up towards the middle of the summer each year. So please check out our Young ICCA website. Second, we also provide access to full tuition scholarships for graduate programs in the US, Switzerland, and China. And we also run a blog which receives edits and publishes short articles on leading issues in international arbitration. Selected articles on this blog are then echoed by Kluwer on their own blog for maximum impact. And fourth, we organize a number of workshops throughout the year, just like this one, focusing on the development of practical skills in international arbitration. So feel free to check out the Young ICCA website to get more details of these programs. And now for those who aren't familiar with our parent organization, ICCA, it's Storied NGO, which was formed 60 years ago to promote international arbitration worldwide. ICCA takes on a number of important activities, which includes producing authoritative publications, like the annual yearbook of commercial arbitration, organizing a biennial congress, which is the largest regular event dedicated to international arbitration, and facilitating training for judges on the application of the New York Convention, and operating a wide variety of projects tackling current issues in the field. If you're still not a member of Young ICCA, we would encourage you to get involved, become a member of the ICCA community, and help contribute to this field that we all love so much. This webinar is structured in 3 parts. First, our 3 distinguished speakers on the panel will share their tips on effective advocacy skills. And then we will move on to a mock session held based on a case which already has been distributed to you upon registration. And this will be then followed by a Q&A session, including live questions. So if you have any questions about the advocacy or anything about the presentation, please feel free to ask them. And in doing so, please use the Q&A box instead of the chat function. You will be able to find the Q&A box at the bottom of the screen. And lastly, this webinar is being recorded. So if you have any objections to be in the recording or your question being read out, please drop off from the webinar. You will also be able to watch the video on our website in due course. So I will now give the floor to Mr. Pasit Asawawa Tanaporn for the opening remarks from THAC. He serves as a managing director of THAC, and before joining THAC, he was a judge in various courts for more than 10 years. He then became a government official and took various offices in the Ministry of Justice, including Deputy Director General of the Department of Special Investigation and Deputy Permanent Secretary to Ministry of Justice and Director General to Office of Justice Affairs in 2015. So please welcome Mr. Pasek.
Thank you very much. Good afternoon for Bangkok and good morning for Europe. Ladies and gentlemen, on behalf of the Thailand Arbitration Center or the THAC, I would like to welcome all of you to the Young ICCA's webinar, Advocacy for Young Practitioners, Tips on Preparation and Delivery of Opening and Closing Arguments in International Arbitration. On this occasion, THAC is honored to have collaborated with Young ICCA, and I sincerely hope THAC will be able to bring you more events such as this on arbitration in the future. As we know, Young ICCA is a leading arbitration knowledge network for young practitioners and students under the auspices of the International Council of Commercial Arbitration, or ICCA. For Thailand Arbitration Center, we are a leading institution for alternative dispute resolution created under the 2007 Act of the Arbitration Center. Our mission is to promote and provide services relating to international ADR. THAC has a state-of-the-art venue of hearings, events, promotes trade and investment in Thailand through the provision of its services, as well as increasing Thailand's reputation as a seat of arbitration. THAC also seeks through its events to strengthen skills and competencies of ADR practitioners. For this event today, the format of which is divided in two parts. Firstly, the panel of experts will share their views on tips and tricks on written and oral advocacy, in addition to best practice in preparing opening and closing arguments in international arbitration. This will be followed by a mock session where speakers will present opening arguments on the basis of a mock case, which will be sent out to registrants prior to this webinar. The overall purpose is to provide practical tips on effective advocacy. Last but not least, I would like to thank Ms. Judith Gill, Mr. John Bank, Professor George Berman, Ms. Wendy Lin, and Ms. Joanne Lau, and all the participants who have joined this event. I am confident that today's event will have provided you with invaluable insights on advocacy from our renowned experts in international arbitration. Thank you very much.
Thank you for the opening remarks. So without further ado, we will move into our first session. We are extremely happy and privileged to have Ms. Judith Gill QC, Mr. John Bang, and Professor George Berman. Ms. Gill, currently the Vice President of ICCA, was a partner in Allen & Overy for more than 25 years and was head of the International Arbitration Group for 11 years. She joined 20X's chambers in Singapore 4 years ago, and now she practices exclusively as an arbitrator. She was only the second female solicitor advocate to be appointed QC in England. She will talk about written advocacy today. Next, Mr. Bang, who will talk about oral advocacy, is a senior partner at Peter & Kim in Seoul. He's a member of the THAC court and one of the foremost arbitration advocates in Asia. He has received several accolades for his advocacy, including in particular being awarded the Dispute Resolution Lawyer of the Year in Korea by ALB in 2019, and being described as a top advocate by Chambers Global. We also have Professor Berman, who's a professor at Columbia Law School, where he directs the Center for International Commercial and Investment Arbitration. And he's also a member of the faculty of the Sciences Po in Paris and the MITS in Geneva. So he will talk about effective advocacy from the tribunal's perspective. We are very lucky to have them all with us today, and we look forward to hearing tips and insights from their experience. So now, Judith, the floor is yours.
Thank you very much, Sammy. So good afternoon, good morning, good afternoon to everyone, and thank you for this opportunity to come join the panel this afternoon. So my topic is written advocacy. Inevitably, given my background that Sammy's described, I spent the majority of my career doing written submissions from the counsel perspective, but I'm afraid I won't be able to resist putting in some comments based on my experience now as an arbitrator. And the two are not incompatible. They really should be aiming in the same direction. So for me, the starting point to anyone who is preparing a piece of written advocacy is to first think about what sort of submission is it that you're going to be making, and what are you trying to achieve with that submission. And it's statement of the obvious maybe, but they're not all the same. So if you're drafting a memorial, it can and should look rather different, and your approach to it will be rather different than, say, if you're preparing a written opening immediately prior to the hearing. In the first case, you're very much trying to set out your stall and explain the case to the tribunal, whereas by the time you get to your written opening or your written closing, you need to be far more focused on what you're doing. You'll have, I suspect, usually some form of word limit. So think about at each stage what you're trying to achieve. And the other thing I would say is put yourself in the tribunal's shoes as much as you can. What will help them to understand your case and, of course, prefer your case? But the writing of a piece of written advocacy, it's not an end in itself. The end is trying to persuade the tribunal. So if you approach it thinking about what will assist them by putting yourself in their shoes, that will likely improve the utility, at least, of your written submission when the tribunal come to writing their award. And one of the most important things to get right is the structure of your written submission. And that requires a lot of thought in advance, may require a team session to troubleshoot on it. What should it look like overall? You need a logical sequence, ideally tied to the decision-making process that the tribunal will need to go through. But it's very important that they can navigate and search through your written submission. If you have a long stream with not properly paragraphed, without appropriate headings and subheadings, the tribunal will struggle with it. They won't be able to dip in and out. And that is what they will need to do. And that's what you will want them to do when they come to focusing in on specific areas. The other thing I would really strongly emphasize in your written submissions is think about your cause of action and what you need to establish your case. And I say this based partly on experience, my own experience as counsel, but particularly as an arbitrator, that there is a tendency, particularly when memorials are being drafted, to tell a story, tell the narrative that no doubt your client will love to read. But there's a real danger then that it becomes a bit stream of consciousness, and there is then a risk that in developing that narrative, the legal requirements get pushed to the background in the process of telling the story, and things can get missed. And I've seen this in a number of different situations. So, for example, causation may be a key part of your case. You have to deal with it if you are making a claim based on breach of contract. Similar other issues, legal issues like reliance, establishing reliance. There is a real danger that these things can be overlooked or not given the degree of attention they need. So get your structure right. Think about your structure. Think about what you have to prove in order to win your case, and then structure accordingly. Another thing I would suggest is avoiding repetition. We all know that word processors make it easy to copy large quantities of text, but that's not usually effective advocacy. The tribunal don't want a 700-page submission if actually you could have written everything you needed to say within 100 pages. They will be frustrated by it. And again, this is there's a lot here that turns on style. It's not a particular length is right or wrong. It depends very much on the particular case. But if you focus on the style that you adopt, that will help. And what you want is to be concise and to use precise language. You don't want long, waffly, descriptive pieces. You want to be very precise in the allegations you are making or the points you're making by way of defense. You want something which the tribunal will enjoy reading. You do not want single line spacing and a tiny, tiny font which they can't read without straining their eyes. You need to present a written submission which the tribunal will pick up and they'll want to keep on reading because it's a pleasure to read. It's well written and it's easy for them to read. And the basic things are so often overlooked. Abbreviations, obviously, we all use them all the time, but they need to be intelligible and they need to be used consistently. And one of the features, for example, when you get a written submission and the abbreviations are letters, and often they'll be very similar. So I'm going to pick some at random. So you have one party who's defined as FLB and the next party is defined as FLD. And you're plowing through this written submission, trying to think now which one was which, and it's not intuitive. So to the extent that you can make things intuitive, that will help your tribunal. Obviously, avoid hyperbole, overstatement. It's just irritating. Avoid outrage, rudeness, sarcasm, personal attacks. You do it in writing and you're a long way away from whoever it is you're attacking, but the chances are at some point there'll be a hearing when you have to look them in the eye. These things often, it might make your client feel that you're going really gung-ho for them, but really there's very little impression, and it can sometimes be indicative of almost a lack of judgment and perceived that way by the tribunal. Hyperlinks, very useful, and to anybody who thinks they can't be done to work with a Mac, yes they can. I have no idea how you do it, but I do know that it can be done and it has been done. But again, think about hyperlinks because they can make life much easier when you are navigating a substantial written submission and with lots of attachments. If you can't do hyperlinks, cross-references become all the more important. And again, when you are preparing a written submission, make your cross-references as precise as you can. Again, when tribunal comes to writing an award and they have a cross-reference, it either just said, oh, see above or see below, and there's no suggestion actually where, or you will get sometimes a very general reference to section 2. Well, section 2 is itself 100 pages long, so you don't know. You need to give your tribunal much more guidance in terms of your cross-referencing. Tackle the difficult points in your written submission. And never try and pull the wool over the tribunal's eyes. Don't think, oh, well, I'll try and get away with that. That is a disastrous strategy, because you will be found out, because your tribunal will end up crawling all over what you have produced. And if they come to the conclusion that you're not being candid with them, or that you're not really grappling with the things that need to be grappled with, then that does undermine your position, and there's obviously a risk that the rest of your work will be looked at with a certain skepticism of whether or not you have really tackled everything that needs to be dealt with. You need to deal with the other side's arguments rather than just staying silent on them, because there's a risk that the tribunal will assume that you have no answer. So whatever your answer is, whether you're trying to minimize the relevance or showing that they've ignored pertinent facts in reaching those conclusions, whatever it is, you have to say something somehow. But equally, and again, this comes back to think about what it is you are trying to achieve with this written submission. The particular written submission may or may not require you to deal at length with the other side's comments. What you don't want to do is start assuming too much of what the other side might say, particularly if you've got a reply that you can put in afterwards. So that is it's a fairly delicate balancing act. If there's an obvious point, deal with it, but don't assume too much in terms of arguments to address if they haven't yet been made. Fundamentally, and I think my time's probably now up, but fundamentally, remember that what you're doing is trying to persuade, whether it's written or oral advocacy. But written advocacy is very studied. This will not be something that's produced overnight. You'll have a long time to think long and hard about what you're saying. Make it effective, make it concise, make it persuasive. And my final point on written advocacy is I would commend to you an article written a long time ago now, but it's still pertinent, I think. In 2013, Bart Legum wrote an article on the 10 commandments of written advocacy in Arbitration International, and I've got the reference somewhere. It's volume 29, issue 1. I would commend that to you as, again, just some of the basic do's and don'ts in written advocacy, which may assist your presentations. And I think, Sami, that's probably my time up.
Thank you so much, Gil. I really like that you gave detailed tips, especially the hyperlink and recommending us to read the 10 Commandments. I'm sure that our participants whose job is to draft the first cut of submissions will find this presentation really handy. So I will now hand over to Mr. Bang.
Thank you. Very good morning, afternoon, or evening to everyone, depending on where you're tuning in from. I must say I'm truly enjoyed Judith's comments on written advocacy, and it's a pleasure to speak with her today. I'm pleased to be speaking at a Young ICCA event, particularly one focusing on oral advocacy at evidentiary hearings. Hearings are quite something, aren't they? They take an incredible amount of work. There is a lot of stress and little sleep. It is definitely a challenging time. Yet there's a reason every disputes lawyer is always willing to launch into hearing war stories. It is where the magic happens. Today's session is focused on oral advocacy in the form of opening and closing arguments. 10 minutes is not sufficient to discuss this in great detail, but like at hearings, we are bound by time limits that always leave us feeling like they're not sufficient. I will focus on some of the things I've learned doing opening and closing arguments at hearings over the last 20 some odd years. My hope is to arm you with advice that is useful when you're preparing for and actually doing your own oral advocacy at hearings. Before I begin, let me quickly address what I think are two myths that surround oral advocacy, sometimes in the minds of students and young practitioners. The first myth is the idea that oral advocacy is an individual act. It is not. It's an exercise that a team undertakes together. Multiple people work on the script, the PPT. Second chair assists the lead advocate. And while the lead advocate does the toughest job on the day, he or she cannot and should not do it all alone. Great advocacy requires good teams working together. The second myth is the treatment of advocacy as an esoteric or intangible skill. Again, it is not. It is a function of preparation and experience. You learn by seeing and doing, and you get better by out-preparing your opponents. Effectively, what I am saying is that your conception of what good oral advocacy is should not undermine the importance of preparation and the team you are working with. In many ways, those two determine how good the advocacy at a hearing will be more than anything else. I will focus more on opening statements simply because while an opening statement is a staple at every arbitration hearing, oral closings are less common. However, before I give you any advice on how I think you should approach opening statements, we must first think about what the purpose of an opening statement is. At the time of a hearing, the tribunal has read written submissions, hopefully, and are familiar with the record, again, hopefully. Therefore, what you are doing is not necessarily informing them, but instead helping them understand what they should be looking for at the hearing. Do keep in mind that the opening is the first time you get to see the tribunal respond or react to your arguments. And it is important that not only do you take note of the tribunal's reactions, but adapt based on it. Effectively, the opening statement is an opportunity to present an accessible version of the legal standards an accessible version of your case to the tribunal. What you are looking to do is clearly articulate what the legal standards are, how they interact with the facts, what the primary documents are, and so on. Your roadmap must make it clear to the tribunal what is agreed and what it needs to decide, and your arguments must convince the tribunal to decide in your favor. Here, based on my experience, I recommend keeping a couple of things in mind. First, you have limited time. Oral advocacy is an exercise in prioritization. Focus on what you think is important. Do not attempt to address every issue. Second, do not be unreasonable or try to overplay your hand. If something is clearly black, you're not going to convince the tribunal that it is white, irrespective of how good of an advocate you are. In fact, trying to do so will make you lose credibility with the tribunal. Be reasonable in your assertions. A question that I think is terribly important and is often decided at the very end is how exactly are you going to supplement your oral advocacy at the hearing? Do you use a PPT? Do you use a hard copy bundle that you provide to the tribunal? Or do you not use anything at all? Of course, with the pandemic and the onset of the virtual hearings, PPTs have been essentially the only option. However, hopefully we will soon return to in-person hearings, or at least hybrid versions of hearings where it would be possible to provide the tribunal with a hard copy bundle of documents. And we are focusing on advocacy today. The question is, what is better and or more useful? This decision is contextual and based on the nature of the case and the aims of the opening statement. For instance, in a hearing that is primarily centered around legal issues, PPTs can be particularly useful to show relevant extracts from legal exhibits as you discuss them instead of everyone flipping through voluminous judgments. They can also be useful if you have a small number of relevant documents and want to show snippets as you discuss them. Sometimes if you want the tribunal to pay more attention to the documents, what you can do is prepare what I call an opening statement bundle, a bundle that only contains the documents you will refer to during your opening and possibly use later during cross-examination. I tend to prefer this approach and often employ it instead of PPTs because mainly the tribunal is interested in understanding the key facts of the case to assist it in their findings. And like all lawyers, they know that the best way to understand the facts is to read the actual documents. Many years ago, I was involved in a case where the other side had attempted to bog the tribunal down on legal issues, including contractual terms, and take them away from the facts. I thought the facts in the contemporary documents were more favorable to us than the law. So I did a 2-hour opening taken the tribunal through all the important documents over a 2-year period that were in the opening statement bundle. Because the tribunal was generally interested in understanding the documents, they did not lose attention. I looked at them to see if they were following along and highlighting the relevant passages. If they were really interested in a particular document, I went very slow and didn't leave it until they looked up at me. At the end of that day's hearing, the opposing counsel came to me and said that the most amazing thing about the 2-hour opening was that the tribunal remained attentive throughout. I believe this was because I was acting as a guide to the documents, presenting the contents of the contemporaneous documents to help the tribunal understand the case and essentially have a conversation with them, rather than just making a one-sided sales pitch. One consideration that I think gets overlooked in this discussion is how do you want the tribunal to file your opening statement? If you're using a PPT, they will have a printout of the PPT in front of them, which they will use to make notes on the hearing or refer to them in their deliberations. If you're using an opening statement bundle, they will have the actual documents in front of them and will highlight based on your speech and later during cross-examination. When deciding this, which path to take, it is important to think about which of these outcomes you prefer. Now, with regard to closing statements, as I said before, they're not as common at arbitration hearings. And in fact, I think a majority of counsel prefer, and I tend to agree with them, is a question and answer session at the end of the hearing, where the tribunal poses questions to the parties. This is useful because it helps you better understand the tribunal's positions on issues and what questions they're focusing on, so that you can prepare a more focused and streamlined post-hearing brief. However, sometimes you have an oral closing and done on the last day after the final witness has been examined. A good closing highlights the documents and the testimony that is most favorable to your case, while simultaneously addressing issues that the tribunal has demonstrated most interest in. I will leave you with a couple of tips that are particularly relevant for younger members of the team regarding the closing. First, if you find yourself preparing for a hearing where oral closing is scheduled, the very first thing you should do is inquire if you would be possible to have a day off between the last day of the witness examination and the day of the closing statements. Going straight into a closing after a week or two of witness examination is brutal on everyone. Second, regardless of whether that schedule can be implemented or not, a member of the team must be working on the closing from day one. He or she should be looking at the transcripts every day to highlight the best testimony and evaluating the questions the tribunal has posed to make sure they are answered during the closing. There should be a PPT draft with moving parts from the end of day one. This will be performed inevitably by a younger practitioner, as the lead advocates will be conducting the opening and the cross-examinations. Well, I will conclude by restating conventional wisdom. The bedrock of good oral advocacy is good preparation meeting good sense. Mastery of the record and the law are compulsory, but a good advocate marries them with the quick wit necessary to make changes based on the tribunal's actions. Thank you very much for your attention.
Thank you, John. It was really educative. Especially thank you for sharing your personal experience and the tips on the closing argument. It's good to know that we can ask for a day off after the cross-examination. So next we have Professor Berman, who couldn't join on live due to time difference. So we will meet him in this video.
I've been asked to say a few words about quality advocacy on the part of counsel in arbitration. And what I have to say is largely common sense. It is largely advice that one would give to anyone who has to make a written or oral presentation of some sort. However, in making these remarks, I am thinking specifically of how it appears to me when counsel stands up in a hearing and addresses the tribunal, or when I read submissions by counsel. I think what I have to say does not depend upon whether the communication is oral or is written. I'd like to divide my remarks in two parts. The first really is in the nature of preparation for what you want to convey and what you should be thinking as you prepare your written or oral remarks. There's one word that captures what I think a tribunal is looking for in all circumstances, and that is what I call a roadmap of your argumentation. And what it consists of, really, is an indication by counsel of the propositions that need to be established in order for you as counsel to prevail. That's how a roadmap begins. And that would mean addressing the question of on what showings does your claim depend? And how are those showings, are those demonstrations logically connected? And finally, how do they inexorably lead to a result in your favor? Once you've laid out that roadmap, then it is ideal for you to cite the basic facts, be they documentary, be they testimonial, that will establish factually all the showings you have said you are about to make. Once you've done that, it might not be a bad idea, certainly in an opening statement or a closing statement, to turn to your opponent's case and do something very similar. What are the propositions or showings that your opponent needs to establish in order for it to prevail? And then, more specifically, in what respects has your opponent failed to establish the necessary propositions? Why are they legally insufficient? And to the extent that the showings your opponent needs to make are legally sufficient, why do the facts, documents, testimony fail to support them? In sum, we need a clear path of logical reasoning coupled with factual support that leads a listener to the result you need. And why does your opponent fail to do so? In doing that, be prepared, I would say, to address not only the strengths of your case, but also the weaknesses, because every case has weaknesses, and be prepared to address them. Identify them to yourself and be prepared to address them. If there's one word apart from roadmap that captures what I have in mind, it is the word I often use in advice to my students, which is the word cogency. Cogency, defined in English as the quality of being clear, being logical, and being convincing and persuasive. Now, all of that relates primarily to how you go about preparing your written or oral remarks. What is your challenge? The challenge is essentially as I've described it. Now, having said that, and having given you some ideas about what I think preparation entails, there is, of course, the phase that can best be described as delivery. You've prepared. How do you deliver? What are the characteristics and features of successful delivery of what I have described as you having prepared? And I have a few suggestions for you, all of which I think will make sense and will correspond to your common sense. And they are the following, and I think they again apply more generally. All else being equal, brevity and simplicity are desirable. If you can say what you have in fewer words, then it is in your interest to say fewer words. The words you say, as my remarks about roadmap suggest, the words you say should have to them a great deal of clarity and precision. Certainly when you're speaking, as opposed to writing, you should do as I hope I'm doing at this moment, is to speak deliberately at a reasonable pace and with clear diction. Now we get to a more substantive matter. You have prepared your remarks, you've structured them. Now when you deliver, maintain that structure. Be sure you adhere to the structure that you have established. Now, in your delivery, there are a few things to seek to do and to avoid. And I think I'd like to close these few remarks with an indication of what those things are. In my experience as arbitrator, I appreciate the following characteristics. First, I think even with a measure of good humor, it is a good idea to have a sober, serious quality to what you have to say. Sober meaning not overly dramatic. Avoid ridicule, disapproval, sarcasm, frankly, drama. No grimacing when you are listening to your opponent. Okay, so calm and serious. Above all, what is needed is, of course, in your delivery, what goes by the name of credibility. How are you to enhance your credibility? This is easier to say than to achieve, but one thing I respond to is the sense that the advocate honestly believes what the advocate is saying. The advocate is saying what he or she is saying, not because it is his or her task to say what he or she is saying, but because it is genuine, it is believed by the speaker, it is said with conviction. The speaker is, in a word, earnest, sincere, believes in what he or she is presenting to the tribunal. In addition, and consistent with everything I've said, it is a good idea to be measured, to avoid anything that resembles exaggeration or overstatement. I think that makes perfect sense. You are more credible when your presentation is proportional. In that regard, I find it useful for counsel to make concessions that counsel can afford to make, which includes, again, acknowledging weaknesses, if there are weaknesses to your case, which, as I said, is invariably the case. It may seem superficially that you should give up nothing, that you should hold your ground on every aspect or feature of the argumentation. But quite frankly, in my experience, if an advocate comes through as honestly and objectively presenting his or her case, that case is all the more effective. Making concessions that you are in a position to make without ultimately undermining your case. That means, among many other things, avoiding making weak arguments. If an argument that you make is weak, you appear to be, in a word, indiscriminate, and I think you undermine your objectives. And finally, if you are aware of concerns that the tribunal has registered, or if you can anticipate what those concerns might be responsive to them. Be responsive to the concerns or doubts or questions that you think are on the tribunal's mind, whether or not the tribunal has articulated them. And anticipate in advance, even if you are the second speaker, anticipate in advance what will be said to detract from your presentation by your adversary. So I have mentioned to you, so far as delivery is concerned, brevity, simplicity, clarity, precision, a proper pace, clear diction, an attitude of sobriety and civility, maintaining the structure that you established when you prepared your roadmap, and deploying every device that you can think of that as a matter of human nature will enhance your credibility. Meaning that what you say is what you genuinely believe that you are measured and avoid overstatement, that you're capable of making a concession that you can afford to make, that you have the judgment and the credibility, frankly, to avoid making weak arguments, and that you're prepared to be fully responsive to what your opponent has said or can be anticipated to say, and to what you think, whether you know it or not, is on the tribunal's mind. So I hope I've conveyed to you that the work of counsel, however complex it may be reduced to two major exercises: preparation of a roadmap, structured, both legal and factual, with the intention of persuading your listener that the result that must be reached is the result that is in your favor. And then having structured your argumentation in the most convincing and cogent way that you possibly can, deliver it in a way that underscores, that emphasizes, that brings home clearly everything and anything that will enhance the credibility of what you have to say. At the beginning of these remarks, I pointed out that they correspond to common sense. But I find that counsel that is most effective is counsel that has observed these suggestions or suggestions along these lines. I think you will, if you do this, I think you will not only have served your client most effectively, but equally important, you will feel when you are done that you've done the best job you can. And that is, quite frankly, very important from the point of view of professional morale. I'm sorry, in conclusion, that I cannot be there to elaborate on anything I've said, to field any questions you might have, and to enjoy the other presentations that you are hearing, and, as I say, to respond to whatever comments, suggestions, or challenges, as the case may be, to what I've had to say. And with that, I bid you goodbye. I trust and, of course, hope that your program is everything that it should be and benefits you very considerably.
So we'll now move on to the second part of our webinar, which is a natural hearing demonstration. We have two very reputed practitioners that will be presenting their opening arguments to you. Representing the claimant, we have Wendy Lin. Wendy is a partner in Wong Partnership LLP in Singapore, and she's currently serving her second term as co-chair of the Young ICCA committee. She's been recommended for her dispute resolution and international arbitration work in various legal publications, including earning the rare distinction of being selected as a global leader by Who's Legal in 3 practice areas. Respondent is represented by Joanne Lau, who's an off-counsel in Ellen Overy's Global Arbitration Group based in Hong Kong. She's the co-chair of HK45, the HKIAC's Young Practitioners Group, and she's an executive committee member of the Rising Arbitrators Initiative. Thank you both, Wendy and Joanne, for accepting the invitation, and we look forward to hearing from you. So over to you, Wendy.
Thank you. Good afternoon, members of the Tribunal. I appear on behalf of the claimant, Mr. Robot. My learned friend, Ms. Joanne Lau, appears on behalf of the respondent, Cyborg Tech. As you're well aware, the dispute before you arises out of the agreement entered into by the parties for the sale and purchase of Mr. Robot's then 100% shareholding in THAC, a company he founded in 2000. There are a few issues that are before you. In the interest of time, given the limited time allocated for opening arguments, my learned friend and I have agreed that we would focus on Mr. Robot's claim for the remainder of the purchase consideration in the sum of euros 40 million. That, members of the Tribunal, arises out of Article 2 to B of the SPA, which is in exhibit number 1, page 2 of the exhibit bundle. And what it provides is that the remaining purchase consideration of 40 million is due and payable to Mr. Robot within 2 years from closing, that is 1st February 2015, if THAC achieves the targets agreed upon in Article 5. The target there is a dispute in this case is Article 5(1)(a). That's what parties have focused their evidence and submissions on, namely for THAC's business to be expanded into other markets, including North America, Africa, and China. In brief, in summary, it is our position that this tribunal should grant the claim for the remaining amount, regardless of whether you accept the claimant's or the respondent's interpretation of the scope of Article 5(1)(a). If I can explain. First, if this tribunal agrees with the claimant that the scope of Article 5(1)(a), it's not limited to the 3 markets set out in that provision. In other words, the target is not simply for THAC to expand into North America, Africa, and China, but into other jurisdictions as well as and when new opportunities arise. Then we say that the only reason THAC did not manage to expand beyond the 3 markets, and in particular into Australia, is because Cyborg, the respondent, refused to cooperate with Mr. Robot, as a result of which THAC lost a very lucrative contract or business opportunity, if I can correct myself. The second argument I put forward before you is that in the alternative, if you agree with my learned friend that Article 5(1)(a) is limited to those 3 markets, North America, Africa, and China, the sum of 40 million is still due and payable to Mr. Robot because the target was in fact met, and there is no evidence before you that suggests otherwise. And in fact, the evidence before you shows, and we would develop this in the course of the oral hearing, that Cyborg's true complaint, it's not that THAC did not manage to expand its business into North America, Africa, and China. Its complaint is that it did this through little effort of Mr. Robot's. We disagree with that. And in fact, again, there is no evidence to support the respondent's assertion. But in any case, I take the respondent's case at its highest. It does not entitle them to refuse payment under Article 2(b) of the SPA. If the tribunal looks at it, the only condition to payment is that THAC has achieved the target set out in Article 5. It has no qualification to that Mr. Robot needs to have contributed a certain percentage towards that target being achieved. With that overview of my arguments, I would like to take the tribunal through some of the documents in the exhibit bundle now to develop our 2 main lines of arguments. And if I can invite the tribunal to first look at exhibit number 1, that is the SPA, and you can find that starting at page 1 of the exhibit bundle. If I can go across to page 2, Article 2, that sets out the purchase consideration for the shares, and what is relevant for this tribunal and what is in dispute in this arbitration is Article 2(b), which provides, as I stated earlier, that the consideration will be paid within 2 years from closing if the business achieves the financial targets agreed upon in Article 5. And that is the only condition to the payment obligation being triggered. If I can go down to Article 5 and 5(1)(a) in particular, the tribunal sees that the target is for THAC to expand its business into other markets, including North America, Africa, and China. It is the claimant's position that the use of the word including shows that these 3 markets are not exhaustive. And in other words, the target is for THAC to not only expand into North America, Africa, and China, but other markets as and when new business opportunities arise. And members of the tribunal, we say that our interpretation of Article 5(1)(a) must be correct, bearing in mind the objective of the parties entering into this acquisition. It was to combine THAC's intellectual property and technical expertise in cybersecurity solutions with Cybok's worldwide business presence and network to create, and if I can quote from Cybok's PowerPoint presentation to Mr. Robot in exhibit number 10, at the point in time when they were thinking about entering into the SPA, page 19, the objective was to create a dominant worldwide entity to provide cybersecurity around the world. Bearing in mind that objective and looking at the use of the word including, we believe that the correct interpretation must be that Article 5.1a is not limited to these three markets. If I can go back to Article 5, the second point I make in relation to Article 5 is if the tribunal looks at the starting words, the words in the start of that article, the tribunal can see that parties agreed to cooperate with each other, and they were obliged to cooperate with each other to procure that THAC achieves targets set out in the following sub-paragraphs. However, members of the tribunal, Cybok failed to do that in Australia. We have put forward evidence before this tribunal, in particular in exhibit number 11, as well as Mr. Robot's witness statement, that through his own efforts and initiative, he managed to put THAC in as one of the two front runners to secure a 1 billion Australian dollar contract to renew Australia's entire military cybersecurity infrastructure. That deal fell through because Cybok refused to cooperate with him to achieve that business opportunity. First, Cybok ignored Mr. Robot's repeated request for updated business information to be provided to him when he was in Australia getting ready for a meeting with the Australian Defence Agency. And that, members of the tribunal, you can find in exhibit number 8, pages 14 and 15. You would see that on 27th of May 2014, Mr. Robot sends Ms. Terminator an email informing her that he has arrived in Melbourne and he's scheduled to meet with, amongst others, representatives of the Australian Defence Agency on the 3rd of June. He requests for the up-to-date presentation of Cybok and Cybok's business plans and objectives. He gets a holding response the next day from Ms. Terminator saying, "I'll see what I can do and get back to you ASAP." And after that, despite chases from Mr. Robot on the 30th of May and on 31st of May, highlighting that it is going to look quite bad for THAC to say the least if it goes into a meeting with the Australian government with not much information about the business and Cybok THAC. He received no response, not even a courtesy of a reply from Ms. Terminator. Second, Cybok's appointees on the board, which formed the majority, then voted not to see through this deal. And the reason given by them for this is Article 5.1a of the SPA is exhausted. So we would only focus and we would only expand our business into North America, Africa, and China. Members of the tribunal, we say that is misplaced. You have my arguments as to how that clause is not exhaustive. And in fact, that must be correct because parties, bearing in mind that business objective of creating a worldwide dominant entity, could not have agreed to just pass up on any business opportunity simply because it falls out of those three markets. Targets are meant to be developed as circumstances change. That makes absolute business sense. Finally, members of the tribunal, even if I assume the respondent is right and the target is limited to those three markets, the claimant is still entitled to payment of the remaining 40 million. And that is why, members of the tribunal, you would find there is nothing in the record contemporaneously documenting any complaints Cybok had about Mr. Robot. The first time we see anything in the record is Cybok sending a self-serving letter dated the 3rd of September 2014 to Mr. Robot. And that is in exhibit number 2. Members of the tribunal, I say this is self-serving because it's sent 1.5 years into the relationship, no complaints before then. And of course, by this time, Cybok knows it has to make a substantial payment of 40 million to Mr. Robot. And that's when it starts documenting its position in this letter. But let's look at this letter, members of the tribunal. The first bullet point, first 3 sentences of the first bullet point, there is that bare assertion that Mr. Robot has not made the required efforts in North America, Africa, and China. There is also the assertion that they have sent repeated reminders and alerts to Mr. Robot. None of these reminders and alerts have been produced in this arbitration. And if we continue looking at that first bullet point, Your Honor, members of the tribunal, you would see at the last sentence, what is stated there is that as a result of Mr. Robot's supposed failure to comply with his part or his duties, other members of THAC and THAC had to substitute for him and assume the additional workload required to meet the aforesaid targets. So here it is a clear admission from Ms. Terminator herself that the target of developing clients in these 3 markets was actually met. And her complaint is that, well, you didn't contribute much to it. Well, again, as I said, we disagree with that, but it's in any case, members of the tribunal, irrelevant. The only condition to payment in Article 2.2b is for the target to have been met. And there you have it, an acknowledgement by Ms. Terminator that the target was in fact met. Members of the tribunal, I see that my time is up, so I will stop here and just conclude for the reasons that I've stated earlier. Either because the target in Article 5.1a was achieved, or if it was not achieved, it was due to Cyborg's refusal to cooperate. For those 2 reasons, we submit that this tribunal should grant our claim for the remaining 40 million purchase consideration. Thank you.
My name is Joanne Lau from Allen & Overy. I represent the respondent, Cyborg Tech, in this arbitration. We've heard the factual narrative from the claimant. The respondent does not entirely agree with it. So what I will do is to set out an overview and also to provide a roadmap on the important points that the tribunal needs to bear in mind in the next few days throughout the hearing. So let me start with the overview. Cyborg Tech and Mr. Robot began discussing the sale and purchase of THAC and THAC in late 2012. Cyborg Tech outlined a clear vision for THAC and THAC. During the negotiation, the respondent, Cyborg Tech, expressed a very specific desire for THAC and THAC to expand into 3 specific markets: North America, Africa, and China. And the reason was given. That was because they were identified as growing markets in the fields of cybersecurity. There is no need to turn up the document now, but for the tribunal's reference, that is the same presentation slide that Claimant's Counsel took you to a moment ago. So that is exhibit number 10. We've heard the claimant talk about Australia. It is important to make clear at the outset the respondent's position on that. It is accepted that Cyborg Tech did not shut the door on the possibility of exploring additional markets. But a very important point to note is that by exploring these other markets, it does not mean that the 3 priority markets, China, North America, and Africa, can be neglected. So that's very important. Turning to the agreement was then signed in January 2013. I would just highlight 3 particular features from this agreement. The first is that the acquisition was for 100% of the shares in THAC and THAC. So upon closing, Cyborg Tech becomes the sole shareholder of THAC and THAC. And we say naturally, it's in our client's interest to see the success of THAC and THAC. The second feature is the deferred consideration. So 60 million euros was pocketed by Mr. Robot upon closing. 40 million euros, is dependent on THAC and THAC's performance in the next 2 years. And this is not an unusual arrangement. One rationale might be to incentivize the seller, Mr. Robot. He's no longer a shareholder, but we want to incentivize Mr. Robot to stay on and cooperate with the buyer in working towards the agreed objectives for THAC and THAC. So the third feature, the agreed objectives, and this takes us to the very important Article 5 of the SPA. It's worth pausing and looking at the wording of 5A again. One point to highlight is that by saying to expand the company's businesses in other markets, including North America, Africa, and China, by the use of the word including, it means that North America, Africa, and China must be included in the markets to be expanded into. I won't read out all the other objectives, but another one to note in particular is the one at subclause C. There's a requirement to conclude 10 contracts per year with new clients. So that is the background to the transaction. Turning to the dispute, it's in fact quite a simple one. We say there are two primary questions that the tribunal needs to focus on when hearing the evidence. First is whether these specific agreed objectives in Article 5 were met and met within the 2-year period. And two, if they were not met, if they were not achieved, was it because, as the claimant seeks to suggest, was it because of Cyborg THAC's attempt to preclude the claimant from pursuing THAC and THAC's objectives? So we say the answer to both questions are clearly no. On the first question, were the objectives met? And we say far from it. A recurrent theme of the claimant's case is that Mr. Robot tried to expand into the Australia market, and the tribunal will no doubt hear more on this throughout the hearing. But the respondent's position is it's important to go back to the wording of Article 5. It specifically includes expanding into North America, Africa, and China. So it's no use for the claimant to say, look at what I tried to do in Australia, because that doesn't change the fact that nothing was done in North America, Africa, and China. We heard from the claimant's counsel today that something was done in those 3 markets, but the respondent's position is looking at the contemporaneous documents, there is no evidence at all to suggest that those markets have been expanded into and penetrated. And for the requirement for there to be 10 contracts per year and with new clients, again, looking at the evidence, there's nothing to show that this objective was achieved. So we say this is sufficient for the tribunal to make a finding that the agreed objectives were not met. So turning to the second primary question, which is, if these objectives were not met, was it because Cyborg THAC precluded the claimant from achieving them? And again, the answer we say is no. General accusations have been made in the arbitration about how Ms. Terminator failed to respond to certain queries, but I would invite the tribunal to look at the contemporaneous documents, and it's clear that the only complaint that is being made is in relation to Australia. And explained just now, we don't need to go there because the Australian issue doesn't move the dial. But even if we look at Australia, we can see from the evidence that Cyborg THAC didn't simply dismiss the Australian proposal. A board meeting was called. There was a discussion about Australia proposal, and after careful consideration, the board decided it was not the best move for the company, and the tribunal will hear more from the witnesses on that. But focusing on the 3 specific markets, North America, Africa, China, throughout Mr. Robot's witness evidence, there's no suggestion about any efforts made by him in expanding into these markets. And there's also no suggestion that Cyborg Tech did anything to preclude Mr. Robot from pursuing these 3 markets. And no suggestion could be made because, to the contrary, my client was very patient and indeed encouraged the claimant to focus on these 3 markets. The claimant has mentioned just now that letters were sent which were self-serving. The respondent would respectfully disagree. If we look at the record, a first letter in the form of a board resolution was sent in June 2014. So that's 8 months before the expiry of the 2-year period, where the board reminded Mr. Robot to focus on these 3 markets. And 3 months later, again in September 2014, so that's 5 months before the expiry of the 2-year period, although the respondent didn't have an obligation to do so, it still sent a letter to Mr. Robot reminding him again to please develop, please expand into these 3 markets. But at the end of the day, nothing was done. So we say the objectives under Article 5 are clearly not met. It's not because of any failure to cooperate by Cyborg Tech. And in light of this, there is no obligation to pay the remaining consideration. So that is all I wish to say.
Thank you very much for the excellent presentations. I'm pretty sure that Claimant's Counsel would like to have some time for rebuttal, but in the interest of time, we will save that for the closing arguments, and we will now invite the comments from the tribunal. Judith, would you give some comments on the opening arguments?
Sure. I thought that was a very, very helpful demonstration. I thought it was very clear. I think, Wendy, starting with yours, I think one of the things that struck me is that when you started out, and as claimant going first, you often face this slight sense of I've got to use my time telling the tribunal what the case is all about, and then by the time the respondent comes along, they don't have to do that in the same way. But it is actually important, and I think that your explanation and introduction is necessary and helpful for the tribunal, that they have that, and also then the clarification of the issue that was going to be addressed, and that the counsel had discussed this and agreed upon the issue. Again, what you're doing is you are giving the tribunal handholds to know how this is going to progress and what they need to be focusing on. Obviously, strong emphasis on the contractual basis and taking them to the contract and the specific provisions, which they will have read, they will have read, but nevertheless, when you're doing an opening like this, it's quite important to actually make sure that they have really got in their mind the emphasis that you place on the wording that is used. And I very much like the technique of, it doesn't matter how you come down on these important issues, we're going to win whichever way you do it. And I think you did that very effectively. You can't always do that. It can go horribly wrong. But to the extent, and here I think you did make it persuasively, that they either accept your contractual interpretation, but even if they don't, it doesn't matter, because the question of whether or not the consideration is payable, even if they are with the other side for part of this, they would still be with you. I thought the one other thing that you could have gone to, and Joanne did then just go to it subsequently, was the board minutes, because I'm not sure I made a note of exactly what you said about Australia, but obviously you have got a board minute of a meeting where Mr. Robot was in attendance, and the reasons given for not pursuing Australia, there are reasons given, and they may not be adequate reasons, they may not be sufficient reasons, but to some extent acknowledging them can be helpful to, if you will, take the sting out of it for when the tribunal then goes back to that document. Joanne, I think your presentation was interesting. It was slightly different. There was, I think, rather less going to the specific documents, but it was very focused on the fact that this is an opening, and what you were saying to us was, you know, I'm going to make some points which you're going to want to bear in mind over the next few days. And of course, that's one of the important parts about an opening submission. Again, you can fall flat on your face if you spend your opening telling the tribunal what the witnesses are going to say, and then they don't come up to proof. So there's a lot to be said, as I think Wendy did, of focusing on documents, because documents aren't going to change. Documents won't let you down. They will still say at the end of the case what they said at the beginning of the case. It's not always true for witnesses. And yeah, you also at one point said, we heard today. Again, shows you're listening proactively to what your opponent has been saying, and then building that into your presentation. And that takes a bit of practice, but it's a very useful thing to be able to do, because it means you can deal with things quickly. And finally, another point I liked was the reference to that it being in your client's interest to see the success of tech and tech. It's that appealing to that commercial logic, because I have to say, when I read the case study, one of the points going through my mind is, well, is it really feasible that they would deliberately stymie development of the company just to avoid the extra deferred consideration? And so it's sort of playing into that. At the end of the day, probably not determinative, may well, who knows, tribunal will have to form a view on the evidence as to whether or not it was right or wrong, but appealing to that sort of commercial common sense, I think, is can be quite effective. That's all I had.
Thank you, Judith. John, do you have some comments?
I guess because of the time, I'll just go very, very quickly. I was very impressed with both Wendy and Joanne. I thought Wendy, when she opened her opening remarks on her two best arguments and going through the record was very good. And I thought Joanne, as respondent, it's always important for a respondent to directly refute what they say in the opening, and referring to some of the arguments directly, I thought was very good. So I think beyond that, they're very good advocates, and I was very impressed.
Yeah.
Thank you both. We will now turn to the third part of the webinar, which is the Q&A session, which will be moderated by Raul. Raul, the floor is yours.
Thank you very much. Thank you also for all of your excellent presentations. We have questions in two formats. We have asked our participants to ask questions to us when they registered for the event, and I have a list of those questions with me. And I would also encourage those of you that would like to ask questions right now, please feel free to do so in the question and answer box. And I see there that we do already have one question, which I will come to in a minute. I'm also a little conscious of the time, and that Judith and John both may have to leave us. So I will just ask, if I may, one question from each of you, or to each of you. We focused a lot already on oral advocacy and the opening statements, and we've had two good expositions of how an oral statement should be made, or an opening statement should be made. I'm sorry. Judith, is there anything particular that you would like to say about closing arguments, and how those arguments are generally to be prepared, or because you're so engrossed in the hearing, when you come to the end of it, you're so exhausted that it's difficult to kind of encapsulate everything that has happened in the hearing into the 1.5 hour, 2 hours that you have for the closing statements. The tribunal is fatigued as well. So any tips that you have on that?
Yeah, I mean, I think John's dealt with quite a lot with the oral closings, but again, I think the reality is that oral closings in arbitrations are relatively unusual. You do get them sometimes, but if you do, it tends to be because they are focused on specific issues. So I mean, in some ways, the contrast then is with written closings, and there it is a bit different, because necessarily you will be given a little bit longer. And I don't know, counsel often thinks, well, I'd like as much time as possible. I often feel that actually you are so engrossed in the case when you are doing the hearing that actually, even though you're exhausted at the end of the hearing, getting the closing done and in while it's still fresh in the mind has an awful lot to be said to it. So again, like many things in life, it's a question of balance, but it is important to write things down, and get your closing sorted while you are while it's still fresh in your mind. And I'll just give you one example. I did a hearing many years ago. It was quite a long hearing. I think it was about 2 weeks. And I then went off on holiday. I think I took my kids to Disneyland straight afterwards, but I couldn't get this case out of my head. And I don't know if it was I was on a roller coaster or while I was just chilling, but I wrote the closing in my head while it was still there. And it was slightly frustrating that I wasn't actually back in the office for a little while. And I think we were talking in pre-laptop on holiday days, shows you how long ago it was. And so I was just sort of writing it down. And it really reinforced to me that actually disappearing immediately, we all do it, but sometimes it's actually better to be there and be focused. I think the other thing I would say is, and John made this point about oral closings and asking the tribunal what they want to be addressed. I think that applies equally for written closings, because you cannot just reproduce everything. You have to focus in on the really key points, and asking the tribunal specifically for questions will help you identify what the really key points still outstanding are for them. So I think whether it's written or oral, that is a very good approach to take. And increasingly, in my experience, tribunals are happy to do that. They will give you their questions, and there is sometimes something of a little dance that's gone through, so they try and make sure that the questions are reasonably balanced, and because parties will always try and interpret what the questions really mean in terms of the tribunal's thinking, but at least having that will help you direct your focus in your written closing.
Thank you very much. That was, of course, a question more for John than for you, and I misspoke when I gave you the floor. But thank you for your comments. If there's anything that John you would like to add on to that, then feel free. But otherwise, I have another question, and this time it is for you.
No, go ahead.
When you're thinking about advocacy in general, and I think this question really applies to both John and to Judith. Do you also keep in mind the background of the arbitral tribunal, in the sense that does your style change, your presentation style, does it change in terms of whether they are from a civil law background or a common law background? Sometimes they have a judicial background. They've worked as a judge for several years and are now sitting as an arbitrator. So do you suggest changing your advocacy style depending on the background of the tribunal?
Well, for me, I don't think there really is a big difference for oral advocacy, with respect to opening and closing statements, whether the tribunal's from a civil law or common law background. I think maybe 15, 20 years ago, I think what may have been a factor is how you conduct your cross-examinations. That's a part of advocacy, and I think if you have if you had a common law background type of a tribunal, then I think you could probably get away with more confrontational or forensic type of cross-examination than you would have gotten when you have three people who are from a civil law background 10, 15 years ago. But I think overall, arbitration has really adapted, and there's really no difference to me how you present your case if the arbitral tribunal is from a different tradition.
Right. Thank you. Judith, would you like to add something to that?
No, I agree very much with that. I mean, most arbitrators nowadays will have had experience of both, unless they're sort of relatively novice, they will have had experience of sitting with both civil and common law arbitrators and parties from both systems appearing before them. So it doesn't really make a lot of difference. The background of the arbitrator may make a difference. So if you're appearing before a retired judge, then they may be more demanding in terms of, for example, questions of admissibility of particular types of evidence. That's one example I've had. There can be it's a fairly nuanced difference, but there can be a slightly different approach to disclosure issues in my experience. But again, I think we are very much talking about peripheral changes, and I think for most arbitrators, as John says, I certainly don't think you would need to change your style. You may just need to be prepared to deal with particular traits of the tribunal that may or may not be reflective of their backgrounds, and not just the civil criminal or civil common law distinction.
Right. Thank you. I think we can take one more, or rather one final question, which has come in through the question and answer box. And the question is, can you please comment a bit on the use of legal authorities during closing statements? How should it be done effectively? And I suppose this question is more specifically towards closing statements, but it also applies towards opening statements as well. I mean, if you have to prepare a written opening statement for the tribunal's use, do you pepper that statement with written authorities? Do you focus more on the facts? It applies both in terms of oral as well as written advocacy, I suppose, and again, both in terms of opening as well as closing statements. John, would you have any thoughts?
Well, as Judith said, there's always needs to be a balance. If you have a strong legal case, obviously you're going to put a lot of those legal authorities in front of the tribunal, and as I said, use a PPT or something to show a particular part of the judgments that are favorable, and apply them to the facts of your case. So, of course, you're going to use legal authorities, particularly if they're favorable and are at issue in the particular matter. I don't think you're going to use legal authorities for how the tribunal should interpret a contract, but if there's certain very important issues related to a particular governing law, then of course you'd have to focus on legal authorities and frankly potentially quote legal experts if they've been used. So
Rahul, if I can just add one point to what John has said. I've seen a lot of written closings where there's extensive authority quoted for something that's not disputed or something that's very tried, and I find that it actually distracts from the main point.
Right. No, of course, I give the floor to John and Judith, but Wendy and Joanne, if you have any thoughts, please do feel free to weigh in. Judith, I wonder if you have anything to add.
I think just 2 points. One is in so many written submissions, it's easy to make lots and lots of citations to legal authorities. I think when you're talking about certainly oral openings and closings, you do need to be far more selective. But one of the things to bear in mind is if you are not going to have oral closings, which very often you won't, and there are important legal issues in the case for which you really want to emphasize particular authorities to the tribunal, you have to do that in opening, because that's the only way you're going to actually be able to address them on it, because once you then get onto the evidence with the witnesses, obviously it doesn't arise if there's no oral closing. So it very much depends on the particular case and how important particular authorities are. But I think it's certainly, you need to think about it well in advance, because the oral opening may be the only chance you get to actually have a discussion and a debate about the case with the tribunal. And if your case is going to turn on that, then you want to have that and probably not just leave it to writing.
Right, absolutely. Thank you very much for all of those answers. We have many questions. In fact, I have a long list here. And we've also received additional questions from the live question and answer box. Unfortunately, I think we're out of time and we won't be able to address all of those questions immediately. But if you do have questions, and this is to the participants, feel free to send us an email and we will forward your questions to the panelists. And I'm sure that they would be happy to answer them subsequently on email. Theo, the floor is yours.
Thank you, Raul, and thank you to each of you for joining us today. I am trying to restrict myself from saying this morning because it's not yet 7 a.m. where I am, but thank you to each of you for joining us, especially to the panelists for taking the time to learn the problem and go through and do the mock for us, and for the timely advice from Ms. Judith Gill QC and Mr. John Bang and others. We really appreciate your presence today. Thank you also to Raul and Sami for organizing, and to the Thailand Arbitration Center for collaborating with us for this event, and also to the attendees. We're always happy to have events for our Young ICCA members and others. And we are going to be having more events in the coming months, and we would like you to watch our space on the Young ICCA website and our LinkedIn and other social media platforms. Again, thank you to each of you for joining us. I think it's been a very informative skills training workshop.
Thank you, everyone. I think this concludes our webinar today. Thank you for tuning in today, and we thank you, our wonderful panelists, for staying with us. We look forward to meeting you in other workshops, and have a great weekend, everyone. Bye.